Hello and welcome to my today's contribution on the Constitution's responsibility for the future, how the debate on climate protection contributes to the development of constitutional thinking. The decision of the German Federal Constitutional Court in 2021, which declared the Federal Climate Protection Act partially unconstitutional, has fueled the discussion about the so-called intertemporal protection of fundamental rights. Do fundamental rights also protect against burdens that only occur in the future? Do future restrictions of freedom already have pre-effects on the present moment, with the consequence that future restrictions of freedom already violate the fundamental rights to freedom now in the present time? These are questions that are of great relevance, especially in environmental protection. However, they also lead into the foundations of constitutional law and raise general questions. Does the Constitution also cover future matters? Does it not only want to regulate the present time, but also the future? Does the Constitution have a responsibility for the future? Does the Constitution also protect people from future violations of their freedom? A series of questions, they all concern the temporal scope of a constitution. Because of the short time available, we can only make a few reflections on this question. They take as their starting point the ecological question raised by the jurisprudence of the German Federal Constitutional Court, but deal with more generally with the dogmatic question of the temporal scope of the Constitution. First, we examine the nature of the Constitution. Does it provide any insight into the temporal extension of the constitutional guarantees? The Constitution is the legal basis of the state. It is created as a specific historical moment, but is intended to determine the basis for political and social life for an indefinite time. The Constitution is a normative framework within which politics, in particular the legislature in parliament, or additionally in plebiscitary decision-making processes, which decides by majority vote, should regulate the details. The Constitution is a system of norms that is self-contained and also complete in terms of content. If parts of this legal system are not written, this does not prevent this statement. Constitutional law can and is, even in important questions, unwritten and must be interpreted from the overall system of the Constitution. In this context, it can be stated that necessary and non-necessary provisions of a constitution exist. Necessary is the anthropocentric value system related to the human being, human dignity as the highest value. Connected with this, the principle of freedom, including political freedom, that means democracy, and the equality of all members of the state community on the basis of their humanity. Provisions on institutions are also necessary insofar as they are necessary for the efficient fulfillment of the task in a state, the functionality aspect, and also insofar as the institutional system is necessary for the implementation of the aforementioned value system. The value of freedom associated with human dignity includes, as mentioned, as an essential part, democratic participation in shaping politics, so that the representation of the people in parliament is evidently a necessary institutional part of the Constitution. Freedom also requires control of state action by the courts in order to ensure rule of law, and freedom also requires equality as a very principle of institutional action. We therefore see an overall system of basic constitutional order that is designed for the long term. The Constitution must develop its normative effect for the entire period of its existence. On the one hand, the normative effect is regulative. That is, the constitutional norms are binding and influence the entire legal system. On the other hand, however, the Constitution is also adaptive. This means it must adapt to changing circumstances in a certain way and react to them. The Constitution is a living instrument. It is evolutionary and dynamic. The Constitution must necessarily include the future in its functionality and its normative effect for the present time. It is part of the dynamics of the Constitution that its regulations are future-oriented and appropriate for the future. Constitutional interpretation in the present time must take into account that the Constitution may only ever regulate the presence with the greatest possible consideration for the future. This applies to developments in environmental protection as well as to developments in many other fields, in the field of financial developments, in the field of social matters, in the field of technological development, in the field of internal and external security, and so on. Of course, it is up to politics, that is, the respective government and legislation, to take all recognizable measures that are important for the present time and, as far as foreseeable, also for the future. By its very nature, the Constitution, as a permanent, comprehensive work of fundamental control of politics and society, must not only deal with the present time on an ad hoc basis, but must also keep an eye on the future. By its nature, the Constitution is at the same time caring, judicially allocating resources, taking precautions. The precautionary principle, which is particularly important in environmental protection, is also a fundamental principle of the Constitution. The Constitution is necessarily forward-looking, resource allocating, freedom preserving, and so on. So we see that the ecological necessities, as they have been the focus of the latest case law in Germany, as well as in other countries, have opened the view to think quite fundamentally about the future orientation of the Constitution and the responsibility of the Constitution for the future. In summary, one can say that the Constitution has a goal that is related to the present time and the future at the same time. The constitutional framework that the Constitution represents can only be good for the present moment, for the present time, if it also takes the future into account, insofar as this is possible and can be predicted. We can see a concrete example of the future orientation of the Constitution in the case of fundamental rights. If it is foreseeable within the framework of a certain development, in the concrete example of the reduction of CO2 gas by a certain point in time, that restrictions on freedom will have to be made gradually up to this point in time. Proportionality under German constitutional law dictates that the restriction on freedom in various time periods up to the final point in time be distributed appropriately. It would not be compatible with the responsibility of the Constitution for the future if the citizen were to be spared too much in the first period. That means if little reduction of CO2 gas and thus little restriction of freedom were to be undertaken, but then in the later periods, an all the greater reduction and all the greater burden on freedom would have to follow. This would then be in an excessive, that means disproportionate burden on freedom postponed to the later period. In other words, the burden of freedom must be measured in the present moment in such a way that it does not create too great a burden for the people then living in the future. This means that the burden of freedom restriction in the future already has an effect on the present freedom situation. That is, that the burden must be bearable and proportionate for the present time and the future. We can therefore see here in the example that was essentially the basis for the decision of March 2021, already mentioned, that the Constitution's responsibility for the future clearly emerges. And we can also refer to the state's duty to protect, which, according to the German constitutional understanding, is connected with the rights of freedom. This means the state's duty to actively protect the freedom, protected in fundamental rights, freedom to act, freedom to life, freedom to health, property, and so on, by means to actively protect this by means of appropriate legislation. This idea of active protection, which is a duty of the state, a constitutional duty of the state, is an idea that applies not only to the present time, but also to the future. The protection of constitutional values must be guaranteed now in the present time and also with a view to the future. Of course, new developments, for example, in the field of technology, must be taken into account here, inasmuch as politics based on the Constitution must then adapt the legal situation and the actual design to these new challenges. Another point of view should be taken into account. The principle of the social state in Germany, enshrined in Article 20 of the Basic Law, in other constitutions enshrined in basic social rights, which do not exist as such in German constitutional law, is a constitutional obligation to shape the future in such a way that it finds its place in a just society and social order, independently of the protection of basic rights. As far as ecology is concerned, Article 20A of the German Basic Law is such a constitutional obligation to protect the natural foundation of life, that means the environment, for future generations as well. It can be formulated more generally that under the aspect of the principle of social state, the future must also be taken into account under constitutional law. The protection of the Constitution must also be able to be effective in the future. This requires careful forecasting in the present time, economical use of the resources, and the will to ensure sustainability in the preservation of resources and to make provisions for the future, for the fundamental social and societal conditions of the future. Careful planning for the future is not only a requirement for a good policy, but also a constitutional necessity. Thank you very much for your attention.